Hello, this is John Sweet. I'm a staff attorney at the Pennsylvania Utility Law Project. We are a statewide specialized legal aid program. We provide technical assistance to local offices. We're available for any consultations on issues regarding utility matters. We are also involved in a number of large regulated utility cases and advocacy throughout the state. On the co-presenting with me today is Jolene Price from Community Legal Services Energy Unit. They are a unit within CLS that does largely the same thing that Pulp does, but focused specifically on the city of Philadelphia. Move on to a brief rundown of the agenda for today. We're going to begin by discussing some issues that have arisen over the response to COVID-19 and some of the emergency steps that Pennsylvania Utility Commission has taken and other entities. Then we'll move on to strategies for preventing termination and connecting and reconnecting service, specifically focusing on reconnecting service to households that may currently be off in the face of the ongoing crisis. And we'll end with a discussion about dispute rights and some other issues. So a brief update. The Pennsylvania Utility Commission has issued an emergency order halting terminations on all regulated utility service. Utilities are encouraged to reconnect, but are not required to for households that are currently off, and we'll go over some of the stuff that can help people get reconnected there. Again, this does not mean that all households are connected. So unregulated utilities, such as municipal water authorities and electric cooperatives, are not subject to the current moratorium. No utilities are required to turn households back on, although they have been strongly encouraged to do so, and they may be a little bit more lenient. The PUC also has issued a second emergency order for the bureaus to allowing the bureaus to just suspend or amend the schedule of any currently ongoing proceedings. This mainly will impact ongoing large policy and large scale utility litigation before the PUC. However, if you have a client who currently has a formal complaint pending before the commission, this may affect the status of that proceeding, and we would recommend checking with the PUC and the utility to see if anything can be done there. Additionally, there's been, because of the overwhelming nature of the ongoing crisis, BCS, the Utility Commission's Bureau of Consumer Services, which takes in informal complaints and payment arrangement requests, is still operating but limited. They're currently accepting cases from customers who are off and whose utility is refusing to restore services. They're also taking in cases that are safety related or deemed to be an emergency or exigent circumstances. They are not taking any unregulated utility off cases. They are referring those cases to 211, the Attorney General's Bureau of Consumer Protection, Office of Consumer Advocate, or if it involves a small business, the Office of Small Business Advocate. They are currently investigating, mediating, and issuing decisions on those disputes. However, the decisions are going to be primarily served electronically via email, with some verbal decisions being issued, and they will begin serving paper copies once the U.S. mail service becomes available. Currently, all mail service from the PUC is suspended. We just want to remind you, please reach out to either Pulp or CLS if you're in Philadelphia. If you have a client that you're working with whose service is off and who can't get through to the PUC to file an informal complaint, we do have email and some other contact information. We may be able to help you get in contact with someone. Additionally, regarding municipal water and wastewater authorities, the Pennsylvania Municipal Authorities Association has issued non-binding guidance to its members to place a moratorium on shutoffs, restore service for those that are currently off, as well as suspending or waiving late fees and instituting payment assistance plans. Again, this is non-binding, but I would recommend reaching out to utilities. Even recommend having your clients reach out to municipal utilities if they're currently off, or if they are have overdue bills, they may be able to get a more lenient payment plan than would otherwise be the case. And with that, I'll hand it off to Jolene to discuss what's going on in Philadelphia and some other issues.
Hi, everyone. Again, as John said, my name is Jolene Price. I'm an attorney in the Energy Unit at Community Legal Services. And so first, just for the Philadelphians among us, I just wanted to cover what's going on with the Philadelphia Water Department, which is not regulated at the PUC level, but they have stopped all shutoffs, and they are actually going through the process of restoring all off customers who were shut off for any reason, except if there was a notice of defect that requires some sort of fix by the owner of the property before water gets turned back on. They're also suspending late payment fees and collection activities as far as we can tell. And I just wanted to note, for those of you who know, the TAP is the Tiered Assistance Program it's the affordability program with the Water Department. And I just want to note, as you're working with clients, that the eligibility is either income-based if you're under 150% of federal poverty, or you can still qualify if you're above 150% if you have some sort of special hardship. And I would argue that losses of income or difficulties because of this pandemic should be at least argued to be a special hardship. So, but our work's not done. We wanted to do a quick note just generally about the continued advocacy that we and Pulp are doing around issues that we're predicting are going to come up and are already starting to come up. Right now there's a shutoff moratorium, but whenever that moratorium is lifted, we're probably going to see a wave of terminations, and we're also going to see other issues related to the fact that people can't pay their bills right now because there's nothing has been done around the amount of people's bills, or whether anything beyond what already exists in terms of affording bills. So we anticipate seeing a lot of issues with large debts and possible terminations. In the immediate term, we're doing some advocacy around extending the LIHEAP season. LIHEAP is supposed to close April 10th, and we think that we've been advocating with the Department of Human Services that they should be keeping it open until they spend their money, or at the very least extending it as much as possible. We're also been advocating in terms of at the PUC level, suspension of CAP removals, customer assistance program removals for non-payment or failure to recertify, so that people are kept on CAP as long as they are, stay on, which should be until the end of this crisis. We're thinking about ways that arrearages that are accrued during this time, debts that are accrued during this time, can be rolled into cap arrearages. These are all, and just to clarify, these are all things that, this is our wish list, right? This isn't anything that is happening. This is what we're sort of pushing for. We're pushing for relaxed income verification requirements so that folks can more easily prove their income in ways that are possible given everything that's going on. We're looking at ways that we can encourage utilities to supplement their hardship funds. And we're encouraging the PUC and utilities to think about ways that they can be more flexible in the payment arrangements that they offer. And just a note about how advocates can help with that. Contact the utilities to push for improved practices, contact local and state authorities, and also just keep us updated on issues that clients are facing. If you're seeing a lot of clients who are really getting pushback on income verification for enrolling into the assistance programs at the utility, like, I think we would like to know that, so that we can focus our advocacy. And then in terms of what we would recommend in terms of advising clients, urging all eligible clients to apply for LIHEAP online or by mail as soon as possible. We continue to push, but there's no guarantee that the season will be extended beyond April 10th, so we really want people to apply before then. And clients who've lost their job or have a change in income, if they're not enrolled in CAP, in the customer assistance programs at their utilities, we would encourage them to call to apply for CAP or apply online if the utility offers that functionality. And usually they look at the previous calendar month's income or the previous 30 days income, depending on the utility. But if they're out of work, we would suggest asking to submit a no income form to say that they don't have any income. If the client is currently enrolled in CAP and has had a change in income, they should contact their utility immediately and request adjustment based on their change in income, because if they have a lower income, their amount that they have to pay could go down based on that readjustment. And if a client has a pending informal complaint with the Bureau of Consumer Services, they should call to check the status on that. So in terms of strategies for utility restoration is what we're sort of going to focus on today. Beyond those updates, the first thing, as you all know, and as John touched on earlier, there is a moratorium at the PUC level on any shutoffs as long as the proclamation of emergency issued by the governor is in effect. But just a note that if someone is off, there's no guarantee, that doesn't guarantee service restoration. Some utilities are restoring folks. I know PECO in Philadelphia is, and I'm not sure if they're the only one, they may be the only one, has put out press releases and information that they are, if you call in, they'll and you're off, they'll restore service. So that is possible in some places. Obviously, LIHEAP crisis is still an option. We'll talk about assistance programs, payment arrangements, and then some of the other options that are still around: medical certificates, security deposit prohibitions, rules about what debts can be used to form the basis of termination or required for restoration, and then protections for customers with a PFA or other court order. So LIHEAP, Low-Income Home Energy Assistance Program, it's administered through the DHS, through the local county assistance offices. The season ends, as of now, April 10th, 2020. As I said, we're pushing to have that extended, but for now, it is scheduled to end April 10th. The types of assistance you can get: cash grants of between $200 and $1,000, depending on your income and other factors. crisis grants for those in danger of termination or off, and then there's also like emergency heater repair replacement program for crisis. And the ways to apply right now, we would suggest using Compass, the online application tool, or if really necessary, applying by mail. For cash household income, the eligibility is 150% of federal poverty or below. And just a note that for LIHEAP specifically, the rules of LIHEAP say that you can either use your last 12 months income or your last month's income. There's some, there may be some benefit for clients who have lost work this month to wait until the very beginning of April to apply, so that the month of income that LIHEAP uses is the month of March instead of February. And then the other requirements for LIHEAP for a cash grant is that you have to be responsible for the main source of heat, either directly or through rent, but you can apply your grant to a secondary heating source. So for example, electricity, if it's necessary for your gas to function, can get your cash grant, or your gas can get your cash grant, and then you must be Pennsylvania resident. For crisis, right now, so the same options exist, the same eligibility requirements around household income and home heating responsibility and residency, and then the additional requirement to get a crisis grant, you can get up to $600 in crisis grant funding, is an actual or imminent home heating emergency that can be resolved by crisis funds. The DHS has said that termination notices are sufficient to meet the crisis requirement when they've been issued, in the context of the winter moratorium after February 1st. We're sort of hitting an interesting area right now where utilities are not currently issuing any termination notices, and so clients are going to have a difficult time obtaining crisis funds, particularly given when the season ends, and we're doing a lot of advocacy for a solution on this and ways that people will be able to access crisis funding when they really need it, but they're not getting termination notices, which is good, but they need, there's this sort of problem of needing the termination notice to get the crisis, but then not being able to get the crisis, and so we're worried about people being able to get crisis funds right now. But if people are off, they should definitely be trying to get crisis funds. And it's the same application for both cash and crisis, and the cash grant will be applied to resolve the crisis first before crisis dollars are awarded. There is a third piece of crisis, a third piece of LIHEAP, this crisis weatherization interface with the same eligibility in terms of household income and home heating responsibility, and it's a heating system repair replacement program. And what generally happens is that DHS will refer applicants to the local weatherization offices, and weatherization providers will conduct a home visit, do appropriate remediation, and install weatherization measures. I'm not sure right now if that's happening because of the concerns around person-to-person interaction and people visiting homes. So I think we would be happy to talk through issues if you have clients who are having issues with their heating systems and are looking for services. We can at least talk through what might be possible. But I just wanted to flag that as a third part of LIHEAP.
Jolene, it is still operating, and they
Oh, it is.
The emergency furnace repair is all of the local agencies have gotten instructions from DOE to continue to serve emergency cases with some leniency for households with vulnerable populations to make sure that they're taking all proper precautions, but they, as of now, they are still operating that emergency service. And I see that
clearly
somebody.
I should have. Yeah, so definitely keep us posted on. Thanks, Liz. I didn't know that clearly, but thanks for popping in. I appreciate that, and so definitely keep us posted on whether or not your clients are able to access those services.
Okay, this is John. I'm going to talk a little bit about payment arrangements and what may be available to clients who are maybe either behind on their bill or currently off and trying to get reconnected. So the agreement, important to remember that your clients should only agree to a payment arrangement for money that they actually owe. By agreeing to the payment arrangement, they are essentially admitting liability to the arrears. So they should not agree to any payment arrangement for money that they dispute that they owe. They should file a dispute as to that amount and then enter a payment arrangement for any additional money that they actually owe. And also important to remember that clients should never agree to a payment arrangement they can't afford to pay. Could wind up getting them in even further over their head. There are two types of payment arrangements. The first is a utility issued payment arrangement. Utilities have vast discretion to offer as many payment arrangements as they want for any length of time. However, every utility has its own internal policies of varying strictness as to the terms and numbers of payment arrangements. If the client is not able to obtain an affordable utility issued payment arrangement, they also have the option of a PUC issued payment arrangement. But I would just note that although not specifically required, utilities have been encouraged to offer more lenient payment plans at this time. So it's always worth a shot trying again, specifically with the utility. The PUC issued payment arrangements, they vary based on the customer's income level. The most relaxed payment plans available based on income level would be the customers at or below 150% of the federal poverty level are entitled to up to a 5-year payback time frame. The PUC cannot require the utility to enter a second payment arrangement absent extraordinary circumstances. However, as Jolene has previously indicated, we believe that the COVID-19 crisis is creating extraordinary circumstances. And we are currently advocating for a relaxation on that rule. Also under 1407 of the utility code, customers are entitled to request a restoration payment agreement for those who are already off, and this is the most likely situation you are to run into during the current moratorium on terminations. And these are for applicants who have been without service for 30 days or longer who are now trying to reconnect. They are entitled to payment arrangements up to 24 months. However, they may have to pay a reconnection fee depending on the utility.
John, I'm just going to interrupt with a question. Carl Bailey asks what's being done, or that we know a lot of people are going to be applying for LIHEAP, and what's being, and that what is DHS doing to try and help the consumers get applications completed. And so I just wanted to pause here before we get too far into the PUC adjustments to make sure that everybody listening to the recording or listening now knows that there has been no further DHS policy changes at this time, but that PULP and CLS continue to work on this with them and to monitor your emails. We will be sending out further guidance as soon as we get changes in place, and we hope that some decisions will be made in the coming week.
Thank you for that. So there are exceptions to the payment arrangement standards, specifically for victims of domestic violence with a PFA or other court order. The restrictions on the length and number of available payment plans do not apply to these clients. They may be offered a payment plan, anything that is considered to be a reasonable period of time based on the balance and income. Factors to be taken include the size of the unpaid balance, the ability of the applicant to pay, the payment history, and the length of time that the bill was accumulated. These are codified in the regulations at 56-285. Another exception that runs the other way is for cap arrears. Customers who fall behind on cap arrears are not entitled to a PUC issued payment arrangement. However, in those situations, the customer or applicant is typically allowed to pay only their missed cap payments to be reinstated into the program. And that differs, that's true at most utilities, but differs among utilities. And reinstatement into the cap should refreeze the non-cap debt and allow for them to return to getting their arrearage forgiveness over time.
Excuse me, John, if I could just interrupt quickly. This is Kelly. For the attorneys that are participating in the webinar today, we're offering one substantive CLE credit. I'm going to now launch a poll that should come up as a box on your screen. Please answer the question, yes or no. You'll have 2 minutes to do so, and you need to answer both of these questions during the webinar. So this is the first one, and I will launch the second one later on in the webinar. Thanks, everybody. Thanks, John. You're free to continue.
Okay, thank you. So moving on to customer assistance programs. Every regulated electric and natural gas utility offers a customer assistance program, as well as the regulated water utilities offer some limited programs. However, they're not required to, and they're not as robust as the electric and natural gas caps. They're available based on income. They provide reduced rates, arrearage forgiveness, and so they freeze the arrears. The customer pays only a discounted bill, and then the frozen arrears are forgiven over time, which is the typical time frame is 36 months, but that also varies based on the utility. Eligibility requirements are typically that the annual gross income the household is at or below 150% of federal poverty guidelines, that the household is payment troubled, and that they provide income verification and update that information through a recertification process periodically. They may ask for a social security number upon application. However, if you have a client who does not have access to their social security number, it is not required, and there are other forms of identification that can be substituted. Hardship fund programs. Again, all electric and natural gas utilities, as well as the regulated water utilities, all have some form of hardship program. Again, the water utilities are not quite as robust as the electric and natural gas utilities. For the electric and natural gas utilities, the cash grants are typically up to $500. However, that must resolve the crisis. Eligibility terms vary by utility. However, the typical terms are that the customer must be 200% of the federal poverty level or below, must have made some recent payments or attempts to make payments. The utility may make exceptions to these rules, but you have to specifically ask them. And it is often required that they show a temporary hardship. Some utilities prohibit current CAP customers from also receiving hardship fund grant assistance, but will make exceptions. We are currently advocating for the utilities to make such exceptions based on the COVID-19 crisis, but that is a work in progress. But it's worth asking if you have a client that is in need of these funds. The CARES program, each of the regulated electric and natural gas utilities does have a CARES program. Programs are targeted to customers who are having trouble paying their bill and have short-term problems or short-term hardships that are causing the inability to pay. They offer several types of services, such as referrals to local social service agencies, budget counseling, and special payment arrangements for bill payment. And just a note that these are typically little used, and that the utilities have wide discretion to resolve customer issues. So if you are in contact with a utility and not getting anywhere, it may be helpful to ask for a CARES referral. And just a note on the security deposits. If a customer is disconnected and seeking to reconnect, they can be charged up to 1/6 of the estimated annual bill, which is about a two-month bill. The utilities have to provide customers with 90 days to pay the full deposits, and they'll be held until the timely payment history is established. It's usually 12 consecutive months. And again, these apply to customers who are setting up new service or customers who have been terminated and are seeking to reconnect. However, for low-income customers, there's a prohibition on charging security deposits for CAP-eligible customers. That's defined as typically 150% of the federal poverty level or below. However, the customer is obligated to provide the proof of income to show that they qualify for the security deposit waiver. For victims of domestic violence with PFAs or other court orders, the 150% of the income level requirement can be waived if the customer can show that they're credit worthy, and ways to show that are through proof of employment, past residencies, letters of resident reference, or a credit report. You can also have the security deposit waived if you can find a third-party guarantor who is the utility deems as credit worthy. And with that, I will hand it back to Jolene to discuss some.
Yeah. Hi. So thanks, John. Another aspect of, if you're looking to try and get folks restored is that there are specific protections for victims of domestic violence who have a PFA or some other court order with evidence of domestic violence. They have to provide the utility with a copy of that PFA or other court order. But an important piece of the protections for victims of domestic violence is that they can't be terminated or required to pay arrears that were required to pay for the purposes of restoration, arrears that was accrued in someone else's name, even if they were living at the residence. So it's worth taking a step back, because the general rule that not everyone is always aware of is that if you live in a property and are on the mortgage deed or lease, you are considered a customer of the utility, even if your name is not on the bill, and could be made to pay those debts before getting service turned back on. If you are if you have a PFA or some other court order that evidences domestic violence, the utility cannot charge you for debts accrued in someone else's name, even if you are living at the residence when that debt was accrued. As John touched on a little bit, victims of domestic violence are also entitled to flexible payment arrangement standards based on individual facts and circumstances, and so there should be an argument for them to be able to get different longer or more flexible payment arrangements, and that could be something that could be helpful in these times as well if you are working with domestic violence victims. And then just when terminations are allowed to proceed again, if someone has a copy of their PFA or other court order noted on the file with the utility is required to provide them with additional notice before termination. They have to attempt what's called personal contact immediately preceding termination. And then if that personal contact is not successful, they have to actually post a notice at the property and delay termination for an additional 48 hours. So that is something that is important to note, and is that as people have are facing termination, and they should be letting utilities know if they have PFAs or other court orders. Medical certificate. Yes.
Jolene, I just want to lift up a comment from Rebecca that in Allegheny County, other court orders is covering consent agreements, which are used a lot in Allegheny County. And I would just add that I think that's the case in many, many, many counties that do a lot of consent orders, and those should all count. If it's signed by a judge, any order, bail condition orders, those types of orders should also be applicable.
Yes, and this is definitely a something that we are happy to talk through with you if you do have you are looking to figure out if something would help someone qualify for these protections. We're happy to talk through with you how to advocate with the utility for those to be covered, because we believe it's a pretty broad category, like Liz was talking about. So the other thing I want to cover is medical certificates. I want to sort of flag and sort of bracket this, because I think right now is not a time when people should be seeking out medical certificates unless absolutely necessary, particularly because they're not going to be able to, with a moratorium on shutoffs, they're not going to need a medical certificate to stop termination. And I think it's probably good to be sort of avoiding the doctor as much as possible in these times. But if a medical certificate can be used, if you have a shutoff notice, it can be used to stop termination if there's a household member that has a serious illness or a medical condition that requires utility service to treat their illness, even if that medical condition itself is not serious. So those are two separate buckets. So for example, asthma that requires air conditioning in the summer, or diabetes that requires refrigeration for medication could be considered medical conditions which require utility service to treat their illness. A medical professional is the person who gets to decide which conditions qualify, not the utility. And it can be, medical certificates can be signed by a doctor, a nurse practitioner, or a physician's assistant. The medical certificate stops termination for 30 days. A customer may submit a new certificate every 30 days if she's paid all current charges by their due date, and you can renew up to 2 times even if you don't pay current charges. But if you pay your current charges, you should be able to continue to renew. Medical certificates, again, are to stop termination. You can also use them to restore if you're within the 30 days since you were shut off, because during that time you're still considered a customer. If you're dealing with folks who have medical issues and are off, I think that you may want to use that to advocate with the utility for restoration right now, given everything that's going on with the COVID-19 crisis and pandemic. But like I said, this is going to bracket this because this isn't going to be something that's super relevant in this instant moment. So also wanted to sort of briefly go over strategies for related to tenant protections. There are 2 different statutes that apply to unregulated and regulated utilities. Unregulated, not subject to PUC jurisdiction, and regulated, subject to PUC jurisdiction. They both are tenant rights acts that protect tenants where the landlord is the ratepayer. If the utility company is deciding to terminate service because of non-payment by a landlord ratepayer, the tenant is entitled to notice of that. The tenant is entitled to notice of before termination, and it has to be proposed termination due to non-payment as opposed to unsafe conditions or repairs or meter tampering. And the notice that's required is that each residential unit that's reasonably likely to be occupied by an affected tenant has to be notified 30 days before discontinuance of service, and then given information about their right to pay the last 30 days, last billing month's bill, not the entire bill, to continue service as tenants. And just a note, and this is something that we see a lot in Philadelphia, specifically with the water department, the requirement is actually on the utility to determine whether a unit is reasonably likely to be occupied by an affected tenant, and not on the tenant themselves to have proved that they are in a tenant situation in terms of the actual notice, in terms of whether the notice needs to be served. And so if you have tenants that are being shut off without notice, that's likely in violation of these laws. Again, because we're not seeing shutoffs right now, hopefully we won't see too many violations here, but it is something just to be aware of as you work with tenants. And then additional protections within that is that if tenants do pay the last 30 days bill, the last billing month, if they are not responsible for those payments under the lease, then they can deduct that amount from their rent owed to their landlord by right, and they are there is a retaliation provision, protection provision in these laws to protect tenants who exercise these rights from being retaliated against by their landlords. And these protections also apply, just for reference, when a landlord voluntarily requests that the utility terminate service. And it's my understanding, at least for the Philadelphia area utilities, they're not honoring any requests to terminate service, but that's something, if a landlord is saying, oh, well, I'm just going to call and request service termination, that should trigger these notice rights as well. And tenants cannot waive these rights under the law.
All right, thank you. I'm gonna this is John. I'm gonna talk a little bit about the Water Services Act. I just also wanted to note on the tenants' rights issues that because of the current situation, the local municipal authorities are not subject to the moratorium on utility terminations, and with the magistrates' courts being shut down, the landlords are not able to file for eviction right now. So this is something to watch out for moving forward, where with landlords possibly failing to pay the tenant water bills, or voluntarily requesting the termination of service as a way to try to force out the tenants while the eviction process is not available to them. So, but moving on also to the Water Services Act, this does apply. These rules are the rules that apply to the unregulated water and wastewater utilities, and so they require notice. So if they require that the water utility shut off service if the customer doesn't pay for 30 days of the due date for the water or sewer, and the water will be shut off until all overdue rents, charges, and associated penalties and interest are paid. There is an open question here on whether a regulated utility can terminate water service as a result of unpaid sewer bill. So I'm sorry, to clarify, I got a little muddled there. The Water Services Act requires the water utility to terminate service to its water services customer for non-payment of a sewer bill at the request of the sewer company or the sewer authority. So the question is, if you have a municipal sewer authority but a regulated water utility, whether the Water Services Act or the Public Utility Code would apply to the rights of the client as to in relation to the water company who is seeking to terminate service. We would advocate for the Public Utility Code. However, it's not something that we have litigated to order yet. Additionally, there are some rights available under Water Services Act, but they're not as robust as what's available under the code. So they are required to provide written notice before terminating. That got to be posted at the main entrance or mailed to the person. But there's no set amount of time that for that notice, and clients must be given an opportunity to contest charges if there is a just defense to all or part of the claim, and they cannot be shut off until the claim till their dispute has been judicially determined, and there should be some dispute process within the utility itself before it makes it to court. Water utility, and also when a water utility seeks to terminate service at the order of the sewer company, they still must follow the Utility Service Tenants' Rights Act that Jolene talked about. And water utilities can't hold a current lessee responsible for failure to pay the bill of a previous lessee, which we have seen occasionally. And that is it for the presentation. We're going to open it up to questions if anybody has any questions at this time.
While people type in their questions, I'm going to take the opportunity for attorneys on the call requesting the one substantive CLE credit for your participation in this webinar. I have just launched the second poll question that we need you to respond to. So if you could do that, that would be great. I will leave it up for 2 minutes or until the webinar is finished, whichever comes sooner. But please type in your questions in the chat box for John and Jolene.
While we're waiting for questions to come in, I'm going to ask a question. John, if you could go back to the slide on the advice for folks dealing with folks without service during the COVID-19 crisis. I think that might be helpful. I know a number of people joined late. And so while we're waiting for any questions to come in, I think it might be helpful to remind folks of the immediacy of the now and what they can do to be helping any clients who are struggling to pay their bills.
Thanks. Do we have any questions coming in?
I don't see anything new.
No. What I would urge folks to do is, you know, the PowerPoint was available through the chat box. So if you haven't downloaded that, please do. We are going to continue to send updates to the utility listserv, to other places that you would have gotten this webinar information about. So please stay tuned on changes in LIHEAP, which we hope are coming. Some live real-time updates. I got a notification while this webinar was ongoing that the House has passed the $2 trillion coronavirus package, and in that is a $900 million supplemental LIHEAP appropriation. So we expect there to be some additional LIHEAP dollars coming, which should push us forward to get some of the things we're seeking. And there is a question, Kelly, I think directed at you. Do we already have their attorney ID numbers to get credit for CLE?
Yes, I do. That was something that was asked on the registration page. So I've got you covered. Okay, if there's nothing else, no other questions, I want to thank everyone for being with us this afternoon. Thank you, Jolene, John, and Liz for putting this together and presenting for us. We appreciate you being there. And be well, everybody.
Kelly, there's a question. Oh, Kelly, there's a late-breaking question,
yep.
Kelly.
Too much breaking news. Okay, do you have that list?
Yeah, so the question is from Megan Williams. To recap COVID-19 advice, what should utility customers who were removed from CAP for non-payment do to be reinstated?
I can try to, I mean, I think that the first thing they should, it depends on, I guess it depends on where they are. If it's been, I think that they should call the utility and ask to be reinstated and provide any updated information. And then if the utilities are refusing to do that, I think definitely recommend getting in touch with PULP and working on advocacy in that on that regard. Liz, would you say anything different?
No, I think that's right. I think the only thing I'll say is that, you know, if they are seriously behind in CAP because of non-payment, certainly applying for LIHEAP and applying for the hardship funds may be able to address those missed CAP payments. We have heard that many of the programs have suspended cap removals for non-payments, but not all of them. So yeah, I think Jolene's absolutely right. Contact PULP or CLS, and we can try the advocacy route, but certainly getting some grant assistance to those households to pay the missed cap payments and help them keep up until we can get some of the broader policy changes in place is a good start.
Okay.
We just see another question from Barbara.
Oh, I don't see that.
So I saw someone raise their hand. Barbara raised her hand, but I don't know how to act on it.
Barbara, if you could type into the chat box your question.
No, that was an accident. I'm trying to get the PowerPoint presentations.
Oh.
Trying to download.
Are you not able? Are you able
chat.
to see it in the chat box and just click on it?
No.
Okay, I can email it out also to you. I have your email address from your registration.
I appreciate it.
Sure, no problem. Okay, well, I don't think there's any more questions. So thanks, everybody. Be well, stay safe, and we'll talk to you next time. Have a good one. Thank you. Bye-bye.
Bye.